Why Supreme Court forgave the shoe attack that took place on Chief Justice of India? What it could have done? What exactly is contempt of court, and could it have been used in this particular scenario? In an extraordinary act of grace, our Chief Justice B.R. Gavai decided not to punish the lawyer who hurled a shoe at him in the Supreme Court. And behind this act of forgiveness lies a complex legal debate, that too about contempt of court. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and today we are going to understand everything about contempt of court and why it was not used to punish the particular lawyer in this particular scenario, what are the balances, and why it is an important provision for the independence of judiciary as well. So let us begin with understanding the incidents at hand. So basically, when the incident took place that a lawyer hurled the shoe at the Chief Justice of India, he decided to not punish the lawyer and there was no action taken on him based on what CGI said. But after that, another bench, which was including Justice Suryakant as well as Joymala Bagchi, they also heard this particular petition and they said that if there is any shouting of slogans or hurling of shoes, yes, that comes in the contempt of court, but it is dependent on the concerned judge. So in this case, because Chief Justice of India decided to not punish and go for the contempt of court implication, here we cannot bring in this, and that is why Supreme Court has refused to put contempt of court in this particular scenario. But the important thing that has been announced remains the fact that the court has brought in the idea that we need to focus on guidelines rather than direct punitive actions. That means they are also talking about awareness and systematic change rather than punishing individuals, so that there is overall understanding and judiciary stands with the dignity which it is expected with. So this refusal and implementation and bringing in of guidelines has placed judiciary in the very right light. So now let us understand contempt of court, what exactly it is. So when we are talking about contempt of court, this is available to both Supreme Court as well as High Court. When I am talking about Supreme Court, it is Article 129, and when I am talking about High Court, it is Article 215, because these are both of court of records respectively, as they are court of record. Supreme Court and High Court, based on these articles, they are having the power to punish for any contempt that takes place of these given courts. So this means that they have a direct constitutional provision which provides them with the power of punishing for contempt. Now, this is not just a constitutional provision, it also has a statutory basis. That means there is a law for it, and that is the Contempt of Courts Act of 1971, which gives a basis of law for the contempt, especially in India. And the whole idea for this constitutional provision as well and the statutory basis as well is to focus on upholding the authority, the dignity, and most importantly, the independence of judiciary. If judiciary would have to be dependent upon any other organ of the government, of the polity, then it will compromise on the independence and also on the authority. That is why judiciary has the power to punish based on any contempt that happens. And it also brings in the public confidence, ensures public confidence, especially when we are talking in terms of administration of justice. When we are talking about the contempt of court, this power is essentially present to maintain the respect for the judicial system. But an important thing that needs to be understood, that in a democracy, when we are talking about respect for one particular organ, it cannot come at the compromise of expression, freedom of speech and expression. So there needs to be a fine balance as well. So how that balance can be assured and what are the other provisions, let us understand about that. So now we'll understand basically what are the types of contempt, basically in which scenarios Supreme Court or High Courts can charge for contempt. There are two types. First one we have as civil contempt, that falls in section 2B. So if there is any willful disobedience when we are talking about a specific court order or a court judgment or a decision. For example, a court has summoned me, I am doing specifically, I am not doing specifically what a court has ordered, that is a civil contempt. But when we are talking the other type, that is the criminal contempt, in this scenario it is usually publication or an act. For example, court has not summoned me, court has not given any judgment, but on my own I am publishing an article, or maybe any act of mine, any speech, any video leads to scandalizing or tends to scandalize the court, or there is a prejudice about judicial proceedings, or it interferes with the administration of justice. In such a scenario, if I am publishing anything about it or saying anything about it or acting in these manners, it will be covered in criminal contempt. For example, if we have many case references to understand this, for example, if you look into EMS Nambudri Pad versus TN Nambiar of 1970, there was contempt of court because the judges were criticized as a class itself which is biased, and it was held in contempt. After that, we have seen many cases, but another one is by Arundhati Roy, where she was punished for scandalizing the court. Then the more recent one, Prashant Bhushan case of 2020, where he had tweeted about judiciary and it was criticizing the court. Here court went ahead with a symbolic punishment because freedom of speech, freedom of expression exists. So there was no harsh punitive action, but symbolic punishment, so as to make understand that there has to be a fine balance between criticism and blocking or scandalizing the court and the administration itself. So you must have understood from these examples that these are case references for criminal contempt, because criminal contempt goes beyond personal insult. It is more about protecting the whole system of justice, not just the judges. But when we are talking about civil contempt, it is usually against an order, a summon. So that is judge specific. In criminal contempt, it is more about justice specific, the more system specific orientation and punishments are seen. Now let us move ahead and understand the legal procedure for the contempt which usually takes place. So there are two sections dealing with it, section 14 and section 15. If the contempt is happening in the face of court, that means the act is taking place in the courtroom itself. The one which has happened with B.R. Gawai or CGI, that in the courtroom a shoe was hurled or somebody shouting slogans. In such scenario, the contempt is considered in the face of court, and the contempt where it is not happening in the courtroom, for example, publishing the article or criticizing the judiciary, in such scenarios, it is considered contempt not in the face of court. In the first scenario, the action can be directly taken by the judge which is present in the courtroom. In the second scenario, the action has to be initiated, and it can be initiated by the court itself suo moto. Can you tell me in the comment section what does the word suo moto refer in this scenario? Second, it can be initiated by Attorney General or Solicitors General consent, or there can be a petition by any person who has the permission of Attorney General or Solicitor General. So the legal procedure are different for the contempt that takes place. Now this distinction is important to understand, that why at this point of time Supreme Court is refusing contempt of court. Because when the shoe was hurled, it happened in courtroom, the judge present there was CGI B.R. Gawai. He decided not to take an action on this and not to punish the lawyer concerned. So once it is happening in the face of court and whatever is the legal procedure, it is not followed, then it cannot be opened under section 15. So that is why this distinction was important to understand. Now let us directly move to understand the constitutional provisions related to contempt of court. So one fine thing that you need to understand in terms of constitutional provision is definitely Article 19, which talks about freedom of speech as well as expression. But that very article, Article 19 itself, also mentions that there can be a reasonable restriction. How can there can be a reasonable restriction? It can be if it is in relation to contempt of court. That means you have the freedom of speech and expression, but if you are saying that something that scandalizes the court, affects the administration of justice, then it can be restricted because it is in relation to contempt of court. And just to balance this with this, there is clear judicial restraint principle as well. What do we mean by judicial restraint principle? The fact that courts must not use contempt power so that they can silence the voices, they can silence or suppress this freedom which exists. For example, we have P.N. Duda and V.P. Shiv Shankar case of 1988, in which there was criticism of judiciary, but it is allowed when it is made in good faith and it is for public interest. So that doesn't mean that judiciary cannot be criticized. It can be criticized, but it needs to be done in right taste. It needs to be done in public interest, not for political interest, not for other agendas, and that's when it is permissible. So this is where we get to see a fine balance that should exist in democracy, with freedom of speech and expression on one side and independence of judiciary, authority of judiciary on the other side. So basically it gives you a clear insight into the fact that contempt powers exist to protect the judiciary, not justice's egos. And in this scenario where CGI has gone ahead and practiced, used judicial restraint, shows the dignity of this system and also that particular post, which also helps in public trust as well as public confidence in this whole system. Now let us understand if this is the only blanket power which is available to the judiciary system, or there are certain exception or defense to it. So when we are talking about allowed defenses or exceptions in this scenario, if there is a reporting, when we are talking about judicial proceedings and it is fair in its manner and also very accurate, that means it is not painted by any opinions. When it is as it is, it will be accepted, and this is something that is allowed. If there is criticism but it is fair in nature of the judicial acts, then it is accepted. And if there is some truth which is present as defense, for example, if public interest is there and it is done in good faith, that also lies in exception. There will be no punishment unless it directly or substantially interferes with justice. And this is what again we get to see in this particular system, because there was no direct effect on justice. This was not addressed with the power of contempt of court. It has been brought in so as to guidelines that over a problem should be addressed, but using the power of contempt of court for unidentified people, for specific justices, does not make sense. It compromises the dignity or the actual power that exists with this particular provision itself. Now this gives us a clear idea in which scenarios contempt should not be used. And the whole idea behind contempt, the key idea, is the fact that it should be used very rarely, sparingly, in extreme situation. Criticism is not the criteria. The criteria is if it's not blocking justice, then it's okay. Now let us clearly understand when can be contempt invoked. There are multiple landmark principles. You can tell me other landmark judgments also in the comment section if you know any. For example, we have Bardakanta Mishra versus Registrar Orissa High Court of 1974 case. In this, it was clearly mentioned that judges should not be hypersensitive. So if anything happens, it doesn't mean they directly go to use the power of contempt of court. They should understand that their dignity rests on the fact that they have public confidence. Another landmark judgment, Justice C.S. Karnan case of 2017. It clearly demonstrated when the contempt becomes necessary, that is when it will be used. When there is institutional necessity, that means the whole judiciary requires that particular interference so as to make sure that their dignity is not compromised, their authority is not compromised. Now that we have understood everything there is to understand about contempt of court, let us understand and talk about the guidelines which have been mentioned by the bench of Justice Suryakant. So in this scenario, the guidelines have been proposed as preventive measures, and these are proposed guidelines as of now. In this scenario, they have suggested that we should go by exploring John Doe orders. That means there can be preventive injunctions against unidentified individuals. So when there is a scenario of individual in the court itself, then that can be handled with preventive injunctions. How that can be done? It can be done by strengthening courtroom security, maintaining proper access control. There should be a proper protocol if any kind of disruptive conduct takes place, and most importantly, it can come with awareness when we are talking about in the bar councils, especially in terms of ethics, in terms of behavior, in lawyers, in other people who are coming to the courtroom itself. So here the idea of not going directly for punitive punishment, punitive acts, here the idea is to bring in a guideline so that such matters can be handled without directly using the power of contempt of court in itself. Now in conclusion, I would like to bring to your attention the simple fact that the respect of judiciary is something that is earned through their conduct, and here we have a classic example. The way CJI B.R. Gawai has behaved, it is something that gives public confidence. He said this act should be ignored and he will keep on working for what he is working. It cannot be, judiciary cannot gain that or force for that respect through fear and through forceful compellment in this scenario. So the whole idea is that contempt is a constitutional safeguard, yes, but it needs to be used with proper restraint and balance, which we have seen, and this is where the real strength of judiciary lies. Now with this, I'll leave you with a practice question. You can put down your answers in the comment section. That was all from my side. Thank you so much.